Morning, this is your Kelso Report for Friday, February 24th, and I'm your host, Clark Kelso. Well, today we have a whole variety of cases: search and seizure, the foreign affairs doctrine, a death penalty case. We find ourselves with a vexatious litigant. We have standing issues. It's quite a busy morning. We begin with the Ninth Circuit and a search and seizure case. Now, in California, we enacted in 2004 an amendment to the DNA and Forensic Identification Database and Databank Act of 1998. The amendment requires law enforcement officers to collect DNA samples from all adults arrested for felonies. The law was challenged on the ground that it violates the Fourth Amendment right to be free of unreasonable searches and seizures. The Ninth Circuit affirmed the district court's denial of the plaintiff's request for an injunction, barring enforcement of the law. Applying a totality of the circumstances analysis, the Ninth Circuit majority found that the state's compelling interest in correctly identifying arrestees, solving past crimes, and exonerating innocent suspects far outweighed an arrestee's privacy concerns, given that the DNA is collected from a buccal swab of the arrestee's mouth, which the majority described as a de minimis intrusion, analogous to fingerprinting, that occurs only after a law enforcement officer determines there is probable cause to believe that the individual committed a felony. In dissent, Judge William Fletcher argues that the DNA samples are not really taken for purposes of identification, and that since, in his view, they are taken solely for an investigative purpose, the absence of a warrant or reasonable suspicion makes the process unconstitutional. This is obviously an important case for law enforcement and for the public, and since Judge Fletcher's dissent argues that the panel decision is contrary to the Ninth Circuit's recent decision in Friedman v. Boucher, it would not surprise me to see this case taken up in an in-bank. Next, the Ninth Circuit dealt with the foreign affairs doctrine. Because the conduct of foreign affairs is vested exclusively in the federal government, the federal courts have developed a foreign affairs doctrine pursuant to which state law that intrudes upon the exclusively federal power is preempted. Now, typically the doctrine applies where the federal government has taken some position and the state law is in conflict with that position. In this form, the doctrine is a type of ordinary conflict preemption. But the doctrine can also apply if the state law intrudes on the field of foreign affairs without addressing a traditional state responsibility. And in this form, the doctrine is similar to field preemption and is known as dormant foreign affairs preemption. Back in the year 2000, the California legislature enacted Section 354.4 of the Code of Civil Procedure to extend the statute of limitations applicable to insurance claims made by an Armenian genocide victim or the heir or beneficiary of an Armenian genocide victim seeking benefits under the insurance policies issued or in effect between 1875 and 1923. It's quite an extension of the limitations period. In Movsesian v. Victoria Versicherung, the unanimous in-bank Ninth Circuit held that this statute was preempted because it did not regulate an area of traditional state responsibility. In response to the argument that the law was simply a form of insurance regulation, the Ninth Circuit noted that it was unlike any normal type of insurance regulation, and that the specific intent of the legislature, as declared in the bill itself, was simply to ensure that Armenian genocide victims and their heirs had a forum in which to resolve their claims. Stated this way, it clearly is framed as a foreign policy initiative of the sort reserved to the federal government. Next, we have a death penalty decision from the California Supreme Court. In People v. Thomas, the Supreme Court unanimously affirmed the death penalty imposed upon the defendant for killing 2 police officers 20 years ago. However, the court vacated that portion of the judgment which purported to impose a death penalty for a third killing, for which he was charged and convicted of only second-degree murder. Well, second-degree murder is an offense that is not punishable by death. Now, rather remarkably, in my judgment, the defense counsel, having raised a series of meritless issues for the appeal that require the court to respond with a unanimous 83-page opinion, defense counsel did not raise the one valid issue on which the court granted relief, that second-degree murder is not a capital offense. That issue was raised by the Supreme Court itself sua sponte. Our death penalty system in California remains totally broken and dysfunctional. Next, California Court of Appeal decision identifying a vexatious litigant. As a general matter, the courts are open and available for persons to exercise their constitutional right to petition government. But as with every constitutional right, it can be abused. And when abused, the right can be limited. We see this play out in the 6th District's decision in Falcone v. Fike, which was an opinion that resolved 5 separate appeals and writ petitions brought by the wife in a long-contested dissolution proceeding. In the main opinion, the court rejected her challenges to, first, a judgment distributing marital property; second, a post-judgment order awarding attorney's fees, costs, and sanctions against her; third, a post-judgment order confirming an accounting; fourth, this one's my favorite, a post-judgment order awarding sanctions against her for appealing an order awarding sanctions against her; and fifth, a pre-judgment order awarding sanctions against her for misconduct in her efforts to obtain a trial continuance. You get the picture here. These 5 meritless appeals in writs were on top of 11 prior meritless appeals in writs in the same matter. Now, sections 391 and 391.7 of the Code of Civil Procedure give courts the power to declare certain self-represented parties as vexatious litigants who are prohibited from filing any new litigation in propria persona without first obtaining leave of the presiding justice or judge of the court where the litigation is proposed to be filed, on penalty of contempt. One way of becoming a vexatious litigant is to commence, prosecute, or maintain at least 5 litigations, other than in small claims court, within the immediately preceding 7-year period that have been finally determined adversely to the in propria persona litigant. Well, the appellant in Falcone v. Fike had over 15 meritless appeals and writs, and she earned herself the label of vexatious litigant. Next, we have a standing case involving homeowners associations. A homeowners association in California has standing under the Davis-Sterling Common Interest Development Act to sue with respect to matters pertaining to damage to the common area of the development. In Glen Oaks Estates Homeowners Association versus Remax Premier Properties, the 2nd District held that the Homeowners Association could sue the realtors who marketed the properties for the developer, where the suit alleged the realtors failed to act as proper fiduciaries, concealed information related to the budget of the development, failed to warn buyers about invalid soil reports, and failed to comply with laws requiring them to provide a final report and other transactional documents. Because of these failures, the plaintiffs purchased their homes, and when soil beneath a common roadway then failed, forced the homeowners to repair the damage to the tune of $3 million. The realtors argued, among other things, that the association did not have standing to sue the realtors, even if the act gave them standing to sue the developers. But the court found nothing in the act that conditioned standing on the identity of the defendant, and the court remanded for further proceedings in the case. Finally, a search and seizure case. A state park ranger had stopped a vehicle that was being driven by a young 12-year-old boy, and the boy and the man who was with him were taken into custody for questioning. An inventory search of the car was begun, in which officers discovered in plain sight in the front seat a book on oral sex, a large container of Vaseline, a digital camera, and a thumb drive. While that inventory search was underway, officers learned the man was a registered sex offender. He made clearly false statements to the officers about his relationship to the boy and the boy's age, and a second thumb drive was discovered concealed in the trunk of the car. In light of this evidence, the court held there was a fair probability that evidence of a crime involving sexual molestation would be found in the digital camera and thumb drive, and the warrantless viewing of the pictures found in the camera and the other thumb drive was supported by probable cause. When they looked on the thumb drives, they found quite a bit of evidence of improper conduct. Accordingly, the 4th District in People v. Haraszewski rejected the defendant's motion to suppress, and the court affirmed the defendant's conviction on 23 counts of child molestation and related charges. Now that's it for today's Kelso Report. Have a great day in the law.